All right. Welcome, everybody. As more people sign in, my name is Cara Willing. I'm an attorney in Genesee County, and I am a council member for the State Bar of Michigan Family Law Section. Today we have attorney Lauren Dickstein and attorney Randall Lewis from the law firm of Lewis and Dickstein out of Southfield. They're both practicing criminal law attorneys who practice all over the state of Michigan. Actually, Attorney Dickstein presented for us about 2 months ago, and on just criminal matters that family law practitioners should be made aware of. And this is kind of a continuation of that webinar. So with that, if Lauren or Randy, whichever one of you want to go first and introduce yourself and what you're going to be talking about today.
Sure. Thank you so much. My name is Lauren Dickstein. I'm one of the partners with Lewis and Dickstein. We're a criminal defense law firm in Southfield, Michigan, where we practice state and federal criminal defense really throughout Michigan, not so much in the Upper Peninsula, but throughout most of the lower peninsula. We represent people from mid to high socioeconomic categories for the most part, but then work with some lower income people as well when it's appropriate. We have 6 criminal defense attorneys, soon to be 7, which qualifies us, I guess, technically as a small firm, but for criminal defense firms, that's pretty large, maybe one of the largest in the state. And we routinely defend clients facing all kinds of charges, including, just as examples, domestic violence, criminal sexual conduct, firearms cases, drug charges, trafficking, healthcare fraud, white-collar crime, child pornography, very routinely, and many others. Both Randy and I went to Wayne State Law School. I've been practicing since '95, Randy since 1992. He's older. We both had hundreds of jury trials over the decades we've been practicing, and among federal and state judges and prosecutors, we have not only just Randy and I, but our firm has an excellent reputation. Our mantra with our associates is that the only thing that enters the courtroom before you and your briefcase is your reputation. I think probably all of us can agree that that's true, and we're treated by opposing counsel and judges accordingly. I'm going to be talking with you about parental kidnapping and custodial interference, victims advocate representation, and new expungement developments in Michigan. And then Randy's going to talk about pre-charge representation, criminal law and family law discovery, where we intersect in discovery issues, and then the 3 most common criminal charges related to family law cases, which are domestic violence, criminal sexual conduct, and child abuse. And then I'll wrap things up at the end, talking about the advantages of building a relationship with a criminal defense lawyer. So I'm getting right into it. With regard to parental kidnapping, it is more commonly charged than people think. I know as family law attorneys, you probably have more exposure than most types of lawyers have to these charges, but not only is it charged more often, but it's threatened all the time. Basically, what parental kidnapping is when one parent or co-parent or guardian keeps a child for longer than 24 hours in violation of a court order for the purpose or with the intent of either concealing that child or hiding them from the other parent. That's a felony punishable by up to a year and a day, which is a really unusual maximum sentence. It allows for a prison sentence, but only for up to a year and a day. And like cases with young adults, first offense drug cases or domestic violence cases, the parental kidnapping statute has built into it a deferment provision so that if someone has no prior record, they can't have the case taken under advisement. Custodial interference is very rare, and that's a misdemeanor, and that's typically when a child has been ordered a temporary wardship, or after a delinquency, the court's taken jurisdiction of them, and then someone entices them not to be with whomever they're supposed to be with. That's very rare. Parental kidnapping is what we talk about more often, and we get referrals from family law attorneys. Oftentimes when there's a custody dispute, someone either perceives or is correct that the custody order is being violated, and they've contacted law enforcement, and the phone rang at the client's house, and it was a detective wanting to speak with them. And even well-intentioned clients can face felony charges because they might misunderstand a court order or occasionally intentionally disregard. And there is a reason to intentionally disregard a custody order, which I'll talk about in just a moment. But these charges are very serious, especially if there's a family law matter proceeding through the court system, because a criminal charge or a conviction can derail custody arrangements. They can impact parental fitness evaluations and lead to protective orders, which can interfere with a parent's relationship with their child. And usually we see two different scenarios. The first one, we call them defense and offense. So defense is when our client, someone's referred to us by a family law attorney, and they've been contacted by the police. So very frequently we can mitigate or even prevent charges if we step in quickly enough to intervene. And I'll give you an example of how we do that. But basically what we do is we ensure that anything happening on the criminal side doesn't interfere with the family law case. And we do that in various ways, such as documenting a pattern of conduct with our client, that they have complied with court orders, that there was some reason for doing it. And under the statute in MCL 750-350A, in provision 7, it gives a defense to a parent in these situations. And it indicates, I'll just read it to you. It says it's a complete defense under this section if a parent proves that his or her actions were taken for the purpose of protecting a child from an immediate and actual threat of physical or mental harm, abuse, or neglect, which sounds very powerful. It's actually not as powerful as it sounds, because dissimilarly to like self-defense, for example, where if you claim self-defense, once you claim it, you have a good faith basis for doing that, it's the prosecutor's job to disprove it. This statute gives the charged parent the obligation to prove their innocence, which is very rare in criminal statutes, but that is how the defense works in this statute. And then the other scenario is on offense, meaning a family law attorney will contact us and say, hey, the opposing parent hasn't returned the child pursuant to the custody order. What can we do about this? Typically what happens is they say our clients contacted the police. They don't want to get involved. That's normally what happens because police hate getting involved in any kind of child custody disputes. They just say, hey, you should call your family law lawyer, take it to the judge. But when they come to us, we can do a lot to force the hand of the police to get involved if that's what's in the client's best interest. We have, after doing this, as you might imagine, for more than 3 decades, we have tons of contacts in law enforcement and the prosecutor's office who we can get to at least take a report, talk to the opposing parent, and potentially consider charges if it bears out that, in fact, they don't have a valid reason for not returning the child. And usually, kind of concurrent with doing that, we get statements and evidence that can be used to dispute any false allegation the other parent might raise, that they believed the child was in some kind of physical danger or mental harm or abuse. So by doing that, we can oftentimes convince the prosecutor that they have to, or the police, that they have to take a report and intervene. With regard to parental kidnapping, I guess I just want to tell you a quick story. So a family law attorney who's referred us cases over the years sent us a case where there was 2 parents who were very devoted to their children. The person who was referred to us was the father, and he very devoted father, and they shared custody of an 8-year-old daughter. And while he was having visitation, the 8-year-old daughter made some comments about a stepfather that made him concerned that she was potentially being abused. And I know that there's false allegations that occur on this topic all the time, but he believed that his daughter might be in danger. And so he contacted CPS and kept the child for longer than 24 hours than he was supposed to. And he did get a call from a detective who who was hostile right off the bat, demanding that he return the child, threatening him with felony charges. And when he hung up with the detective, I called his family law attorney who contacted us, and we immediately went into action. So we contacted the detective, informed him that we happened to know him from a couple of previous cases, and we got him to back off to give us a chance to provide information. Usually our experience is that once we contact a detective and say, hey, we have some information that will be relevant to your investigation, give us a minute to put it together and provide it to you. They almost always take us up on that rather than potentially look foolish by acting too hastily. We then got documentation from showing that we contacted CPS or that the client did, phone records. We put together a timeline of events. We got previous communications, or some text messages in this case from the dad that wherein he expressed some concerns in the past about some troubling things at their home, the mom's home. So that sort of helped give us some corroboration or credibility to his concerns. We documented that he texted, and we actually got the dad to text the mom before we did all this, that, hey, our daughter is at my house. She's here. You're welcome to come here and see her. But I'm not letting her leave, he said, at the instruction of CPS, because we wanted to be able to dispute or prove that he was never trying to conceal or attempted to hide his daughter's whereabouts, which is part of the charge. And then we also were able to document a long history of compliance with court orders with the help of the family law attorney. And then ultimately the detective backed off, or the issues were concerned or were resolved, and then no charges came from that. So that worked out really well. So again, the burden of proof, if your client is accused, is on them. So they have to be very well documented. You can't rely on the old phrase of, well, you got to prove it beyond a reasonable doubt, because the burden is on the accused person to prove they're innocent. So again, we help with that all the time. The second thing I want to talk about is victims' rights representation and consultation. And by the way, if there are any questions along the way, I don't mind being interrupted, or we can wait till the end. If you can just kind of keep track of whatever questions you have, I'm more than happy to talk with you about that.
Yep, and just as a reminder to people, I put it in the chat box, but the chat box is not open, but the Q&A box is open if there are any questions as we go through.
Thank you so much. So I want to talk with you briefly about victims' rights representation. This is a way underserved area of the law. And I don't know why more criminal defense firms don't focus on this, because you really can provide a very valuable service and make a huge difference in people's lives. And sometimes your client isn't the accused. Sometimes your client is the alleged victim of a crime. And there are reasons why they might want a private attorney to help them as it relates to the criminal investigation or the criminal matter. Although Michigan law gives victims enforceable rights with the Crime Victims' Rights Act, victims' rights are frequently trampled on. They're either not considered, or they're considered hysterical or not taken seriously, or they're spoken to in a condescending way by judges, prosecutors, and law enforcement. And if you build a good relationship with a criminal defense lawyer who's familiar with victims' rights advocacy, they can help with all that. And that might really matter to a family law case, because if the opposing parent is either charged or convicted of a crime that they committed, and your client was the victim of that, that really can help with the family law case, whether it's asset distribution, or typically it's more common than not, it's possession of the home, preventing them from being harassed or intimidated or treated aggressively by their former spouse or soon-to-be former spouse, or with regard to custody matters. And your client may want to have input on bond conditions, plea deals, and sentencing, but unless they have someone speaking for them aggressively, they may not get an opportunity to have that kind of impact. And their participation, your client's participation in a criminal prosecution, whether they're cooperative or uncooperative with the government, can make a huge difference. So there's several different reasons or parties in a criminal case that your client should be able to communicate with and have an impact on. The first being prosecutors. Very frequently, I can name the counties, but I'm not going to do it, where they just give very little credibility to victims. Conversely, the new attorney general, they have a new policy where no deals are approved unless the victim is on board. So that's the converse and very rare. But that's the current position of the current attorney general. But very few state prosecutors and even fewer city or municipal prosecutors really care what the victim has to say. So a criminal defense lawyer will know who to speak to make it so that their voice counts. And why do prosecutors do that? Maybe they're lazy. Maybe they just are afraid to try a case, or they don't want to deal with a defense lawyer and they just prefer to settle a case or give a generous sentence agreement to make a case go away. When a prosecutor makes a sentence agreement, that's called a Killebrew agreement. And so they might fail to communicate. They can be condescending and dismissive and just generally fail to consider the victim's opinion. And then you might say, if you have any familiarity with criminal defense, wait a minute. Prosecutors very frequently have their own victims advocates that they assign. To the victim. It's a complete scam. Prosecutors and victim advocates work for the prosecutor. They're way more interested in getting the victim to do what the prosecutor wants. And they really should be called a prosecutor's liaison, not a victim's advocate. When our firm is hired, not only do we speak for the client, but we deal with prosecutors who are dismissive and unresponsive. And then if they're not going to comply or listen or give us the time of day, believe me, we will move up. And this is not just us, any good criminal defense lawyer who knows what they're doing, who you have a relationship, will move up the chain of command to make sure that they listen. The second person the victims should have a right to have a voice with are the judges. Many judges agree to sentence agreements, which are called in court with judges Cobb's agreements, or plea bargains, often thinking that the prosecutor or someone has consulted with the victim. And in many occasions, that's not true. And if they knew the victim's opinion, they might not so readily agree to the defense and the prosecution trying to work something out if it disregards the victim's views or opinions or their safety, most importantly. So when a criminal defense lawyer is hired to be a victim's advocate, first of all, they enter an appearance, typically call it a victim's advocate appearance, and they appear in court, where many lawyers don't get recognized because they don't have the benefit of being respected or known. It's important, if you're going to have a relationship with a criminal defense lawyer, to make sure it's someone who's known in that court, respected by the prosecutor, because that person's more than likely to get some traction with regard to having the case called and being able to speak on behalf of the complainant. The only time the victim has an actual legal right to speak in court in front of the judge is at sentencing. And on a lot of occasions, that's just too late to have a real impact. But at sentencing, you have a right to speak. We had a case, for example, in Oakland County in front of a circuit judge where the prosecutor made a representation that the victim in the case agreed with the settlement, which wasn't true. And then they were going in to put this sentence on the record, and they hired us. We entered our appearance. We knew the judge really well. The judge let us speak and even let us file a sentencing memorandum on behalf of the victim. And we blew up the deal. Sorry for the prosecutor and defense attorney that we did that, but they didn't do the right things to make the deal legitimate. And once that was done and we were involved, we participated as victims advocates, and a new deal was struck with a sentence that our client could live with, and then the case was placed on the record. Had we not been hired, certainly the prosecutor's victim advocate would have never been involved and done what we were doing. I just heard that my partner may not be feeling well, so I'm going to keep going, and if he'll chime in if he wants to take over. Other than that, I'll sort of go more slowly, tell more stories through my portion of this. So the third party that you really want to voice with is law enforcement. And in many occasions, especially when there's family law matters pending, police officers just loathe getting involved in these cases. And so when a client of ours has been the victim of a crime, we develop something called a prosecution package. In many occasions, that's what the police officers generally, when they do an investigation, they put a package together, deliver it to the prosecutor, usually in a warrants division. And that prosecutor looks at the facts, looks at the law, and then determines what the charges are going to be. So when we get hired, we do the same thing. We create a prosecutor package, but give it to the police so we can say, hey, here's the statutes, where the criminal statutes that the person violated. Here's the evidence that we know of that you can rely on, some we can procure on our own. Defense lawyers don't have the power to do investigative subpoenas, so we can't subpoena information, but we can tell them how to get it. And then in many occasions, we provide supporting letters, documents, affidavits that go to the elements of the crimes. Once we do that, a police officer is much more likely to say, okay, I see what you're talking about. I see that this isn't just something where someone's trying to gain an advantage in a family law case. So they will take the time to go through it, investigate, issue subpoenas if they need to, and then present the case to a prosecutor. So I guess I'll give 3 quick examples on each of these different parties, how we can have an effect. So for example, one case, we had a client charged with criminal sexual conduct. It was very complicated because our client was deaf. They spoke only Arabic. They didn't speak English. He was illiterate and extremely obese. And the victim in the case was also deaf. And they had gone on a date, and second date didn't go well. It turned into a sexual assault allegation. And meanwhile, based on what the allegation was, we not only felt that our client couldn't physically do what he was being accused of. After speaking with the client, looking into the case and his history, we were absolutely convinced that it was a false allegation. I was certain of it. As best as I can be, because obviously I wasn't there, but I really believed him. The case went to jury trial. The prosecutors, victim's advocate, sat with the alleged victim, and our client was found not guilty. And I said to the victim's rights advocate, I said, really, you should switch sides of the courtroom, because our client was the victim of a false police report. And she looked at me like I was crazy. But that's just an example of how they are aligned with the prosecutor. They're not always out for what's in the victim's best interest. Another example, we had a case in Kalamazoo County where there was a high school reunion, and a bunch of old friends got together, many of whom lived out of state. In this case, our client and the person who attacked him lived out of state, and they were visiting Michigan. They were drinking, having a good time. And one of the guys that was at this party was the old flame of our client's high school sweetheart, who he married. And this guy just didn't appreciate the way our client was talking to his wife, and he got in his face and started assaulting him. Ended up with a broken orbital bone, 3 fractured ribs. And the police were called, but it were like, these guys live out of state. It's a misdemeanor offense. It's called aggravated assault, which is a 1-year misdemeanor. They just did not want to prosecute. So we were hired, contacted the officer who filed the report. No response. Then I contacted one of the detectives. No response. Head of the detectives division. No response. Then I contacted the chief. We sent an email to the chief of police, assistant chief of police, all the detectives, the officer, and the local prosecutor. Then we got a response, and they did an investigation, and ultimately it resulted in charges, resulted in a plea, and fortunately restitution, which paid for our client's medical care. There was no prosecutor's victim's advocate who was available, and had he not hired a lawyer to intervene who knew what to do, he would have never gotten the restitution for his medical bills, and the person who attacked him would have never been prosecuted. And then another story with regard to prosecutor. We had a case where a client was accused of felonious assault, which is assault with a dangerous weapon, with a kitchen knife, butcher's knife, and a belt. And it was a domestic situation where husband and wife get in this huge argument and ends up in the hallway of the apartment complex. It's loud. She was screaming. There was definitely hitting going on, and a neighbor called the police. Police responded, and as many times they do, they start with the woman in the party and spoke with her, and she claimed that she had been assaulted with a knife in the belt, and she had marks on the top of her arms that clearly were from the belt that the husband had been wearing but was now off. They weren't interested in talking with him, and he was charged with felonious assault. A couple weeks, maybe 3 weeks later, the complainant, the wife, called me and said, "Hey, I want to talk with you about what happened. I attacked my husband with a knife. I was chasing him, and he took off his belt to defend himself. He was swinging it at me and smacked it on my arms. Ultimately, I dropped the knife, and the neighbor called the police. I didn't want to admit that I threatened him with a knife." And the wounds were very consistent with that story. He had a small cut on the inside of his forearm, and she had these belt marks on the top of her arm, which is where they would have been if she was holding the knife in the way she claimed to be. Anyways, I went to the prosecutor and talked with the prosecutor about it. She did as well. And the prosecutor just took a position. She had been threatened or was dependent on him and was making all this up and wouldn't listen. And the prosecutor's victim's advocate was worthless. So she ended up hiring a private victim's advocate, someone I know in the area who's a great lawyer, who was very aggressive with advocating her client's position, said that she's pleading the fifth because she didn't want to get charged with filing a false police report. We met with the prosecutor, and ultimately he decided to not grant her immunity, which would have forced her to testify, I think because he knew at that point it wasn't going to help him. And then the case was ultimately dismissed. So those are all the ways that we can help someone if your client is ever the victim of a crime and need someone to advocate for them. And then sometimes they might be the victim of a crime, but they might want to handle it within their family, or they don't want the court's involvement, or they want to deal with it through family therapy. Prosecutors typically don't dismiss cases for those reasons, but with a very aggressive victim's advocate, oftentimes we can make that happen if that's in fact what the alleged victim wants. So the third topic I want to talk with you about is major developments in Michigan with regard to expungement. Things have completely changed, and this can have a substantial impact on family law cases as well. So it used to be that getting an expungement in Michigan was very limited. It was one felony and up to 2 minor misdemeanors, meaning 90-day misdemeanors or less. No crimes under the Motor Vehicle Code, for example, no first offense operating while intoxicated. But this does, prior convictions can really, I'm sure you all know, can have an effect on a family law case. It can affect your client's credibility when they testify. It can affect dispute over custody. Definitely, we've had many people who have argued in family law cases and then come to us to try and get rid of a OWI conviction when a parent's trying to use that as leverage in a custody dispute. And we can often not only help, but use, and again, this is not just us, a really good, connected, well-known criminal defense lawyer can often speed things along by pulling favors with the attorney general to get a background check more quickly, or a court clerk to get a hearing more quickly to try and get rid of a conviction. So like I said, old law, up to 1 felony and up to 2 minor misdemeanors. New law is unbelievable. It's called the clean slate legislation. It's way more complicated than the old law, but way more opportunities. So up to 3 felony convictions, unlimited misdemeanors. Motor vehicle code offenses are all now eligible. And something I really never thought would happen in Michigan, a first offense of OWI, or drunk driving, is now expungible. We also have something called automatic expungement, which is up to 2 felonies and up to 4 misdemeanors, but it's very limited, takes years longer. It doesn't help with firearms rights restoration, which many people want. After a criminal conviction and they lose their right to possess or own firearms, they want that back. And the FBI has taken a position that they don't recognize Michigan's automatic expungements because the federal statute requires an order reflecting an expungement. And with automatic expungements, you don't get an order, it just is removed from your record. We've kind of found a unique way around that by filing for a motion documenting an expungement. And the judge will oftentimes just give you an order saying, this order hereby recognizes that you had a conviction which has been expunged, which the FBI might take. So if you have a client in this situation, criminal defense lawyer can help evaluate the client's eligibility very quickly, file the petitions and represent the client in an expungement hearing, and give the client the best possible chance of getting a clean slate and a brighter future. This is especially powerful when a client is seeking custody or visitation rights, or, you might have a client, oftentimes, if there's a spouse that's a stay-at-home mom or dad, and they have a conviction, now they have to seek employment, and they have a criminal conviction that might interfere with that or getting a promotion. So an expungement can help with those scenarios. Two family law case examples. For example, one, we had a client who was referred to us by Macomb County. I think this one, it was in Macomb County, a family law attorney. The person was a dentist, but they had 2 prior fraud convictions from years before. And so but he was able to practice dentistry and had a practice. But that lawyer was very concerned because they knew there would be a deposition, interrogatories. It's a very high asset case. And they wanted, before they filed the divorce complaint, they wanted those convictions removed. So it hired us, we rushed it through, got the convictions off, and no longer was an issue for purposes of being admissible in a deposition or in court at trial if it ever went that far, but it didn't. And then the side benefit was that he had been excluded from billing, for the life of me, I can't remember if it was Medicaid or Medicare, one of the two. And then he was able to hire a medical licensing lawyer who filed a petition and got him eligible to bill, which helped his income. So we really helped in that scenario. And then another one was someone who had an OWI conviction. And under the new law, we were able to file a petition to get that off. And the reason the family law attorney was concerned was, what raised their suspicion that it was going to be a problem, was as they were having a breakdown in their marriage and both talking to lawyers, she started texting her husband about how he's a drunk and shouldn't be around their kid. And it had been 7 years since he was convicted, but he wasn't drinking, he was sober. But the family law attorney who referred it said, hey, I think they're going to try and make a claim that he's drinking again. Of course, getting rid of the OWI doesn't get rid of that allegation, but certainly he felt would make it easier to defend against that kind of allegation. And then we got that done. So I love that people are able now to get rid of that first offense OWI, because in many occasions that results from a lack of judgment, not someone with a chronic alcohol problem. I don't know if Randy's there, but if you want to hop in, go ahead. Otherwise, I'll just keep on going. So lastly, I want to talk about the advantages to developing a relationship with a criminal defense lawyer, in either in your area or someone you trust, who you can know you can reliably work on positions that are common in both of your cases, or just clients you have who have a criminal matter that they might need help with. So the first and maybe arguably the most important reason that referral relationship is important is you make a phone call, get a check. Most criminal defense lawyers do not pay referral fees, but if you check, many of them you can find do, and you establish a connection with that person so that if you have someone to refer out, you can get some compensation from making that call. Never bad to get checks. Also, having a criminal defense lawyer who you have a relationship with is helpful, because you just may have questions from time to time that touch upon criminal law or the criminal area or victims' rights. Their client might not be ready to hire someone, but at least they'll have someone they can talk with. And giving someone that time to talk with them about their case, a family law attorney, then that helps build loyalty between you, helps them give better service to their clients. And then for the criminal defense lawyer, you have someone you're establishing a rapport with who could lead to business in the future. A big one is loyalty. So I can just speak to us because I don't know how many other criminal defense lawyers handle this part of their practice. But we tend to have lawyers who refer us, we have their backs with their clients. I'm sure none of you have ever had a client who's dissatisfied. I'm sure that's probably never happened. But from time to time, people have unrealistic expectations or become disgruntled or get caught up in their own emotions and blame someone else. So frequently when a case has been referred to us and the client will talk with us and say, hey, I'm having this problem with the lawyer who referred me to you. You know, they're not doing something I want them to do, or they're not communicating. Very frequently, we talk with the client at the very beginning and say, if you're going to hire us, we want to be able to talk with your family law attorney and discuss the case. So for that purpose, at least between us, we need you to waive attorney-client privilege. That's usually never a problem. So we can call you and say, hey, there's a problem. They don't feel they're being communicated with. We can talk with the client about having realistic expectations, but just generally have your back to preserve that relationship so you don't have problems. And then also, when that person comes to us, and you really want to check if you develop a referral relationship with someone to make sure someone does this as well, that when you refer them a case, that's your client, not theirs. So if they come back to that criminal defense lawyer and say, hey, I've got now an issue with trusts and estates, or I need a will, you don't want the criminal defense lawyer or anyone you refer cases to say, well, yeah, I got someone. You want them to refer them back to you. So that's one thing you just want to make sure that you have and can trust them to do. And then also, you hopefully will go to someone who doesn't do family law, because you certainly don't want to refer someone to a lawyer who then notifies you later, by the way, I'm also going to take over the family law case. That will be a call you regret making. And so you just want to ensure that someone does just the type of law that you, whether it's personal injury or trust and estates, you want to refer to someone who doesn't do what you do, so you don't have to worry about them taking your referrals. And then the last thing, I guess, to be aware of when you're developing a referral relationship with any kind of lawyer is you're going to get referrals back. So you just want to be cognizant of who they give their work to, and is their work to give you back. You know, at our firm, for example, we have 6 current criminal defense lawyers, 7th, assuming she passes the bar, which I know she will because she's brilliant. We'll have 7 criminal defense attorneys soon, with a whole wealth of potential clients to refer to family law attorneys. So those are things you want to look for when developing a referral relationship with someone. So I can look back real quick at the things Randy was going to talk about and touch upon them just briefly while we have, about 6 more minutes before we, I guess, open it up to questions. But Randy was going to talk about pre-charge representation. It's unbelievable to me, but so many criminal defense lawyers, when they get a call from someone saying they've been contacted by the police, give the worst legal advice I've ever heard, which is, if you get charged, call me. There's nothing we can do at this point. That is horrific advice, because there is so much that can be done on a pre-charge basis, as far as mitigation, negotiating with the prosecutor or the police officer for lower charges or to avoid charges, getting the client rehabilitative services like therapy, substance abuse evaluation, all the kinds of things that can help mitigate for purposes of plea bargaining or sentence later. And lawyers who tell clients who are under investigation, just wait and see what happens, miss all those opportunities. I can't tell you over the years, I'm talking probably dozens and dozens of cases where people have called us under investigation for domestic violence, criminal sexual conduct, child abuse, where after we've intervened, the charges were not filed. We had a firefighter just the other day who was being accused of forcible criminal sexual conduct against a woman. And there were text messages on his phone where she texted him what a great time she had. She wanted to see him again. And he was saying to her, I don't think this is going to work out. I don't feel like we have a connection. And then she got very vindictive in those text messages. We can present things like that pursuant to the rules of evidence in a way that it's part of settlement negotiations. So things that we provide can't be used against our client, where if he presented that information and then had to talk about it, would be manipulated into saying incriminating things. We stop that charge from ever happening. And then with regard to discovery issues, very frequently we're consulted on things like interrogatories, impending depositions where the client maybe accessed their spouse's email when they shouldn't have, or went on their device and they're concerned about identity theft or using a computer to commit a crime. We can help talk with the client about if they're going to talk about it, how they could talk about it, how they could phrase things, not how to lie, but how to phrase things, and then potentially take the fifth if they need to, and the legal justification for being able to do that. So we can help with those issues. And then I think Randy, the last thing Randy was going to talk about was the three most common referrals from family law attorneys. I'm sure you guys already know this: domestic violence, criminal sexual conduct, and child abuse. And, good criminal defense lawyer will know either how to reduce those charges if the evidence is strong, or take the case to trial. You certainly want to refer things to someone who tries cases and has a track record of winning, or potentially get the prosecutor to dismiss those cases. So I'm happy to answer any questions about anything that I've talked about, or any of the topics that Randy was going to talk about. Feel free to ask anything you'd like.
You'd mentioned like working with people who, have both a criminal case and likely a kind of a CPS case, like CSE cases or allegations thereof. When you're referred those cases, do you often contact the investigating like caseworker, or do you leave that for the family law attorney to handle, or do you work in tandem?
Sure. Working in tandem is almost always best. So collaborating and talking about it is really important. In our experience, it's better if we handle any communications with CPS. They have a waiver that we sign with them to allow them to talk with us. I've heard more than one CPS worker say we don't talk to lawyers, which is ridiculous, but that happens. But for the most part, they do, and they're pretty reasonable. They almost always want to do a home visit when there's a CPS investigation. We go to those. We don't FaceTime or sit on the phone with the client with us on speakerphone. Our lawyers go to those meetings. We tell the client exactly what the CPS worker is going to do. They're going to check and make sure you have hot water. They're going to check and make sure you have heat. They're going to look in your pantries. They're going to look in your kid's bedroom. They're going to ask you, how do you discipline? What are your forms of discipline? So we go through all that with them. And then also, if the CPS worker tries to ask about the allegations, we don't want them to put in a report, which they love to do, that they asked questions and the person refused to answer or was uncooperative. We're there to say, hey, look, our client has been we've instructed our client not to answer those questions. We'll do that in a different venue, in court if we need to, so that they don't put in the report that the client was uncooperative. We don't care if they put in the report that we were uncooperative, but always better if we are involved right from the beginning with CPS. Oftentimes those cases will turn into criminal charges, and we often see that detectives are in the background, oftentimes feeding the CPS worker topics to talk about or questions to ask, because they know once a defense lawyer is involved, 99.9% of the time, the defense lawyer is not going to let that person talk to the detective, so they can use the CPS worker as their conduit. We're wise to that. We don't let it happen.
With the domestic violence charges, we've experienced with the way that the law is written, like the victim, even if they take their statements back, sometimes you'll get a prosecutor who still is going to prosecute. So is it recommended for that person to get a victim's advocate in that type of case then, where they, like what you had described, where the lady had approached the guy with a knife and, even in domestic violence cases, if they get, you should they should get a victim's advocate.
Well, it's maybe the most important in that scenario because prosecutors become very threatening. In many occasions, here's the most innocent scenario. Someone contacts the police because there's an argument and they feel threatened, but nothing physically has happened. Police officers, when they come out for domestic violence cases, they're almost always, they have a policy that they have to make an arrest. To do that, they have to justify it. They will very frequently get someone to say, well, he pushed you or brushed you by, and that might have been intentional when he passed you and your shoulders, hit one another. They'll get them to say something, or worse, put something in the police report that's not accurate. We've had many occasions where police officers put in reports, she or he said this, and the person comes to us and says, I absolutely did not say that. We've even seen it on body cams where it proves the person didn't say it, but if there's not a body cam, what proof do you have? And then the person goes to court and the prosecutor says, if you don't say what's in the police report, we will charge you with perjury, filing a false police report. So in those scenarios, when someone either wants to retract the statement, they feel it was exaggerated or misinterpreted, when we get involved, we go talk. We first of all tell the prosecutor, don't talk. You're not allowed to talk to our client. You go through us. If you do want them to testify, they're taking the fifth, so you have to give them immunity. A lot of prosecutors have never even seen an immunity agreement. They don't know what it entails. So we can be very technical with regard to making sure that it has to have all the T's crossed and I's dotted to make it official. A lot of times they won't go through all that, so they're forced to dismiss the case. There was a statute passed in Michigan, which is still on the books, which allows the prosecutor to introduce statements made to the police in domestic violence cases. But in a federal case, the name of the case is Crawford, it says that the Constitution trumps state statutes, and you have a right to confront your accuser. So even though the prosecutor might not want to dismiss if the victim takes the fifth and won't testify and they can't give them immunity, they don't have a choice because under Crawford, they can't admit those statements. And unless there's a third party witness, there's no case left. So they have to dismiss the case. So none of that would happen without a retained victim's advocate, because the prosecutor or the prosecutor's victim advocate would 100% manipulate that person into doing what they wanted. You'd end up with a prosecution, potentially a conviction that's unjust.
We have two more questions. Have you had any cases with secret camera in bedroom situation? What is reception by detectives, police when victim spouse only filed report during a divorce case? What would be charged?
Yeah, we actually have a case that's ongoing. It's being handled by one of our associates. Divorce is pending, and there is a device in an electrical plug in the bedroom with a camera pointed at the bed. So before we were involved, the police contacted husband and said, hey, did you put this in? And he denied it. Meanwhile, there's an SD card in the plug that had a picture of him and his face as he's putting it in the wall. That claim didn't work out very well. And then his secondary position was it was for security purposes. And because under the statute, you can put cameras in for security purposes, even if they incidentally surveil someone in their underclothes or intimate situation, if it's legitimately, and there's a legitimate reason for it to be there for security purposes, that's a defense. So that didn't work out well in that scenario either for him. We were able to mitigate it and make the case go away in a favorable way. But yeah, we've 100% seen that. And again, anytime there's an ongoing divorce case, our experience has been, at least as it relates to allegations against women, police officers are generally very reluctant to get involved. A little more willing when there's a male suspect. Why that difference exists anymore, I don't know. But yeah, having a pending divorce case definitely can make it either more or less likely they'll prosecute depending on the type of allegation. Domestic violence, more likely. Other scenarios, theft of money, damage to property, much less likely to prosecute if there's a pending divorce.
The second question is, and does a waiver of claims in the divorce judgment affect any impact, do you think, in the criminal case?
No, it has no impact whatsoever. As I'm sure you all know, you cannot legally waive your right to prosecute or prevent someone from testifying. That is in itself a crime called obstruction of justice, or witness intimidation, witness interference. Those are all Michigan crimes. So no, a waiver doesn't affect a criminal case, nor does a non-disclosure agreement or a sealed settlement agreement. None of those things can be used to block someone from either making a police report or testifying.
Well, we do not have any questions right now. But is there anything else that you haven't touched on, or you covered a lot?
Yeah, I mean, we could go on all day about various things. Another thing, for example, that just occurred to me is a lot of times when we get a referral, a family law attorney didn't know not to let their client take a polygraph. A lot of times when there's an investigation, police will say to someone, "Will you agree to take a polygraph?" And they ask their family law attorney, "Should I do it?" And the family law attorney feels, "Well, it's not admissible in court anyways. So why not? If you pass, maybe they won't charge you. If you fail, can't hurt you." That advice couldn't be further from the truth in many different ways. But what many people don't realize is that the person who does the polygraph for the police, they're not hired because they're great at reading a line graph that's going back and forth. Their expertise isn't their vision, because anyone can read the charts from a polygraph to determine whether or not it shows deception. The people who do polygraphs, their expertise is interrogation. They're expert interrogators. Their job is not to do the polygraph. Their job is to do the post-polygraph interview, which is to get the person to admit things that can hurt them when they're charged. So you should never allow someone to take a polygraph. You should always refer anyone who's being asked to do that to a knowledgeable, experienced criminal defense lawyer who will immediately stop that from happening. And the only way we ever allow someone to take a polygraph is if we first do a private polygraph with someone who's very credible. And the advantage to doing that isn't to get past polygraph to say, "Hey, look, my client passed. They didn't do it." Of course we do that, but that's not the main reason. The main reason is that private polygraph examiner's job is to tell us whether we should or shouldn't submit the person for a state polygraph. Will they pass or not? With a great amount of accuracy, they can tell us if they're going to pass or not before we make that referral. And then we always allow them, when we allow them to do it, not always, when we allow them to do it, we make sure the detective knows that we do not give consent to a post-polygraph interview. The client does not waive the right to counsel or to remain silent. So once the polygraph's over, the client gets up and leaves without talking to the detective. That way, if it doesn't go right, it can't really hurt them because they don't get caught up in that post-polygraph interview with an expert interrogator who's not looking to find the truth, but who's looking to get a confession. I think that's about it. But if anyone has any questions, you can submit a question through our website, which is www.notafraidtowin.com, or feel free to email or call Randy or I anytime. We'd be more than happy just to answer your questions and talk with you about any issues anytime. We have tons of people here who can do that, and we're very open and free with our willingness to talk with other lawyers and review cases.
Well, thank you, Attorney Dickstein. And as you know, if anybody does have questions, I can always forward those emails to Lauren or his staff. And this webinar will be available, the recording, if you missed the beginning part of it. And Lauren, thank you so much. And Randy, I hope you feel better if you're still there.
Well, thank you so much. It's last time it was fun. This time it was fun. Anytime.
All right, thank you.
All right. Take care.
Bye.